FELTS versus State.
Please, the court. Good morning. My name is Kurt Erlenbach, and I have the privilege of representing Mr. Marshall FELTS this morning in this criminal appeal. I'd like to begin my argument with a discussion of what's listed as issue 3 in my brief, whether the court erred in admitting similar fact evidence without submitting that similar fact evidence to any burden of proof, in allowing the state to present the evidence without a determination whether the unconvicted similar fact crimes had been sufficiently proved.
Counsel, I've tried to read your brief with attention, and I've looked at the McLean case, but I confess I have not been back to the record yet. Could you explain to me how this issue was raised to the trial court?
The defense made a pretrial motion in limine, and there was a non-evidentiary hearing at which the state argued the brief 2-paragraph Williams Rule notice that they had submitted, and argued.
What did your notice say?
Well, there's a state's notice. I mean, it listed the two.
I thought you said it was the defendant.
No, this is the state's Williams Rule notice.
Okay. So they filed a notice saying that we intend to use Williams Rule evidence.
Right. And of these two nieces of the defendant, that the defendant, I don't recall the exact language, the notice is in the record, but that the defendant had engaged in various kinds of sexual contact with the victims, with the Williams Rule victims, at various times and places, roughly, I think, 2 or 3 years prior to the incident here. Remember, the charge incident occurred, the alleged to have occurred in 1977. The Williams Rule charges, I believe, were alleged to have occurred in 1975. But nonetheless, there was a non-evidentiary hearing. No evidence was presented. The defense argued that by allowing the Williams Rule evidence in, it would become a feature, that there's been no proof. This was unconvicted. He had not been charged with the Williams Rule crimes, and that it had not been subjected to any level of testing. The court denied the defense motion in limine, and at trial, the whole kitchen sink came into evidence. There was evidence of...
Was the failure of the trial court to first determine that there was clear and convincing evidence of the similar fact evidence, the Williams Rule evidence, was that specifically argued to the jury in the motion in limine hearing or trial?
I believe it was argued in the motion in limine hearing that it had just been subjected to no level of proof. I don't know that the words clear and convincing, I don't recall them being used at that hearing, but that was the fact that there had been no standard, no burden, no specific level of proof had been.
So we've got the Williams Rule notice, and then we've got a motion in limine. Those are two separate motions.
Right.
So it was raised on two separate occasions.
Well, and then it was again objected to at the time of the trial. But there was a pretrial non-evidentiary hearing at which the Williams Rule evidence was discussed. But it was,
and the court was told that you can't do this unless you find by clear and convincing evidence.
Well, I cannot say it was said in those specific words. That it was argued that because he had not been convicted of the Williams Rule offenses, the Williams Rule evidence has not been subjected to any burden, to any level of proof, and therefore should not be admitted.
It would obviously be different if there were judgments of conviction.
Sure.
Then we wouldn't be arguing about this. But because this fellow was never subjected to trial and was never convicted, your basic argument is that the trial judge must make a finding by clear and convincing evidence that, that he committed these offenses before they're allowed to be presented to the jury.
Well, that's right. That's not just my argument. That's the Supreme Court's ruling in McLean, that it has to be proven by clear and convincing evidence. The Supreme Court in McLean repeatedly uses the phrase gatekeeper, that the trial court has to be the gatekeeper of what comes in. That relates similar to our issue 2, that the Williams Rule evidence that was allowed in is...
What evidence? You said this was a non-evidentiary hearing. This was just a hearing that the state attended, that you attended in the presence of the trial court, and what evidence was presented to the trial court to establish that these...
No evidence. There was argument. There was no evidence.
Well, basically summarize the argument for me that the state presented in terms of evidence that this fellow committed.
It was largely legal argument. There was some discussion of some general similarities, young children, relatives, that sort of thing, young girls, but the argument focused mainly not on facts, as I recall, but largely on legal argument about whether this evidence meets any kind of legal standard, which was odd in that, the facts, obviously it's tough to argue the legal standard without focusing much on the facts, but the facts that developed at trial were repeated sexual abuse, not only by Mr. FELTS, but by his wife, vaginal penile penetration, all sorts of things, notably not the same sexual act with which he was charged against the victim. The bottom line is that the evidence that was presented at the trial, when it actually came out, when it actually was presented, was significantly dissimilar to the evidence that was charged. And so we have a circumstance where, again, the court just abrogated its gatekeeping function here by allowing every bit of Williams Rule evidence in, just based solely on a ruling that it does not that the probative value does not outweigh the prejudicial value does not outweigh the probative value of it, and as a result, it all came in. So I'd suggest that McLean requires a reversal here on these points, because on both issue 3 and 2, similarly 4 and to an extent 5, our issues in the brief also relate to the way the Williams Rule evidence was presented and the way that it was argued at trial.
Have you got those page references for me for where this was brought to the trial court's attention?
Yes.
Because I looked for it in your brief and I just couldn't find it.
The notice of intent is 76 and 77. State had a memorandum on the Williams Rule 30 and 30 to page 41. Defense response 42 to 51. The transcript, I believe, is page 1516 to 1532. The state's order, actually could have done a better job in putting together this record, but the state's order regarding the Williams Rule evidence is at 53 to 55.
What about the motion in limine that you were referring to?
(42 to 51, I believe.
42 to
51.
Is your motion in limine?
Yes, it's titled Defense Response in Opposition to Admission of Evidence of Other Crimes, Wrongs, or Acts of Child Molestation.
Okay.
Sarah.
Okay.
The Williams Rule evidence took up the huge bulk of the trial here. The state's presentation was relatively brief, but the defense rebuttal was extensive, and in fact took up, by my estimation, roughly 85 to 90% of the trial. We argue that the court allowed the Williams Rule evidence to become a feature, and it's a bit of a different argument as frequently presented in that the state, I would acknowledge, did not make much of a feature of this. They didn't put on lengthy testimony about it, but because of the nature of the evidence, the defense was required to present very extensive evidence relating to this Williams Rule evidence, and because of that fact, the Williams Rule evidence became a feature of the trial, which I suggest, as pointed out in the brief relating to the state's final argument, by the time they got to the final argument, the victim and what the victim said had occurred was practically, it was lost in the smoke, was lost in the shuffle here.
I don't mean to disrupt your train of thought, but I need to go back to the prior issue we were discussing, and it has to do with the standard of proof. How long did this hearing last? When the trial judge made the ultimate ruling that this would be allowed in evidence.
Well, I wasn't trial counsel, and I don't know.
Does the record indicate that you're saying that there were no witnesses called, there was no evidence presented, this was just basically a legal argument presented to the trial judge? Do you have any idea how long the hearing was?
Well, just from the pages that I cited, it would seem to have not been very long, perhaps 20 minutes or so would appear from the number of pages that the record takes up. You recall this case had been convicted once, returned to the trial court. There had been tremendous history of this case prior to this hearing. So many of these issues had been addressed, have been dealt with to some extent previous to it. So, but I don't believe the hearing is very long. But I would suggest that based on McLean, that the court has to have an evidentiary hearing if it's going to exercise the gatekeeping function that they talk about there. The court has to determine how similar it is, go through the other factors that the court discusses in McLean to determine whether the under amended 9404-2, whether the evidence is properly admitted. The amended 9404-2 would in essence allow in any evidence of child molestation in any child molestation case. Any prior evidence or post-charge evidence of child molestation would appear to come in under the amended statute, but in McLean, the Supreme Court makes it clear that the court has to balance it against 9403 in determining the prejudice and the prejudicial value and the probative value of the evidence. So there's no way for the court to do it other than, I would suggest, at an evidentiary hearing. I don't think that merely listening to argument without actually...
I don't know. You may have confused me. Just, when the trial judge makes a finding that is sufficiently similar, that's not by clear and convincing evidence, is it? I mean, I understood that what we were talking about is Williams rule evidence of prior bad acts where the defendant had not actually been convicted of those prior bad acts. And in order to establish that it was the defendant that committed those prior bad acts, the state has to present or make a sufficient showing by clear and convincing evidence that there was a connection between the defendant and the prior bad acts.
Well, but identity is not an issue here. And that's the relevance. That's why McLean is so important here. In a case where identity is not an issue.
I know, but my question is, in terms of the trial judge finding that it's sufficiently similar, I mean, that's not a finding that the trial judge has to make by clear and convincing evidence.
No, it is.
It is, you think so?
McLean says it is, that the court has to find that they occurred, that the offenses occurred by clear and convincing evidence.
Right. But once you find that the defendant is the one that committed these prior offenses, then the trial judge has to determine whether they're sufficiently similar to the offenses being prosecuted.
Well, the rule of McLean is that when identity is not an issue, the court has to find by clear and convincing evidence that the offenses occurred and then find that they are sufficiently similar to be relevant.
Go ahead.
I'd like to reserve remaining time for rebuttal if I could.
You have about a minute and a half.
Good morning. May it please the Court. I'm Carmen Corrente for the Attorney General's Office. I concur as far as the motion in limine was involved. I believe that it was very brief. As I recall the record, and I didn't bring that part of the record with me, of course.
Let me tell you what's bothering me about this particular case. In looking at your brief, you devoted approximately half a page to this issue. And basically what you did was cite Barber v. State, which is an opinion out of this court, which basically says that, you know, the showing or the finding doesn't have to be made by clear and convincing evidence. Yet we have numerous cases from other district courts that say the opposite. But more importantly, we have an opinion from the Florida Supreme Court that says, and I'll quote, the trial court must find that the state has proved that the defendant committed the collateral acts by clear and convincing evidence.
Correct.
And so basically all you did was argue in your brief a decision from this court that says that's not the standard. And the Florida Supreme Court says it is. Now, explain to me what evidence or what showing you made to the trial court to allow the trial court to make a finding by clear and convincing evidence pursuant to McLean.
Okay. Please let me back up. McLean came out long after I wrote the brief.
I understand. I understand. In fairness to you, I know that.
Thank you.
I
Okay.
understand that.
Actually, at the hearing and pretrial, it didn't happen. I didn't see anything in the record where it shows that the judge made the finding pretrial. What he said, well, first of all, the motion in limine involved ex post facto only. It was all about ex post facto. Wait a minute, in the first trial, you couldn't get this evidence in. Now in this trial, you're trying to bring it in under the new rule. That's an ex post facto violation. That's what the discussion in the hearing was all about. It was not about, well, judge, you know, you've got to find that the defendant actually did this, that be connected to this crime. And so the judge issued a several-page ruling that was correctly cited to you, I think, in the record, agreeing that.
But what evidence did the state present, or what showing did you present to the trial judge before the jury heard this testimony that would allow the trial judge to make a finding by clear and convincing evidence that the defendant was the one that committed these prior bad acts?
There was no finding other than what we know about in the record.
Are you arguing some sort of waiver because they didn't specifically argue, judge, you know, they're supposed to make the finding by the showing by clear and convincing evidence, and you're supposed to make a finding, therefore they didn't argue it, therefore it's waived? Is that what you're arguing about?
Well, I'm arguing that if it's error, it's harmless error because of the overwhelming evidence of this other offense.
You didn't argue harmless error in your brief, but let's assume that there was an error.
Right.
And now you want to argue that it was harmless. And what is your showing? You have to establish, I think, beyond a reasonable doubt that this evidence did not affect the verdict, don't you, before we can say that it was harmless?
Well, what I think I have to show, at least, is that the evidence, first of all, let's remember that in the first trial he was convicted without this evidence. Now we come to the second trial, and this evidence is introduced, and we have to show at the very least what we should have shown and what the judge should have made is a finding that is by clear and convincing evidence that the defendant committed the crime.
Well, you admit there's no such finding. I mean, the trial judge didn't make that finding. You didn't present anything to the trial judge that would allow the trial judge to make that finding in the first instance, did you?
I don't believe that's in the record.
All right, and we also know that if the Williams rule evidence is wrongfully admitted, there's a presumption that it's harmful, isn't there?
Correct.
All right. And in order for you to overcome that presumption, let me quote to you from the case laws. The state must show that there's no reasonable probability that the error in the admission of the Williams rule evidence contributed to the conviction. Now, show me how you can meet that burden in this particular case.
In this particular case, though, I want to back up with McLean that came out long after the case was decided. The clear and convincing standard wasn't there in this district when this trial was taking place.
But let's assume that when the Florida Supreme Court renders a ruling like that, it's a pronouncement of a general rule of law that's retroactively applied. We're not talking about whether it's prospective or retroactive. We're talking about the Florida Supreme Court resolving an issue, based on general principles of law. And when they issued McLean applied retrospectively to all cases, didn't it?
Well, I would say in the pipeline, and I won't disagree that it wouldn't apply to this case, but I think what you would need to do at this level then is to look and see whether there was clear and convincing evidence.
Okay. I think the clear and convincing evidence has to be presented to the trial judge before it ever goes to the jury. We don't look in the record and see what was presented to the jury, do we? We have to look in the record to determine what was presented to the trial court before the jury ever heard any of this.
In a normal case where that finding was first required, but in a case where the judge did not have that requirement, I think this court can look at whether or not there's clear and convincing evidence that was presented to the jury.
Let me ask, did they adequately raise the issue that there needed to be a standard of proof met before the judge could allow the jury to hear it?
No, that wasn't raised at all by the defense. That wasn't even what they were contesting. They weren't contesting the fact that we have evidence, direct testimony from the victims with corroborating evidence as to when they lived in the home, even from the victim, from the defendant, I mean.
Well, that's not what Mr. Erlenbach said. He said that the question of the standard of proof was raised to the trial judge. Didn't I hear him say that?
I believe, yes, I heard him say that, but I'm not sure it was brought up in that same way in the motion for limine. No, I don't recall. I'll have to. I don't have it with me, and I can't refer to it. But they focused on the ex post facto.
Well, it's the trial judge's responsibility to make the finding. The trial judge under McLean is supposed to make the finding.
Correct.
And the trial judge is supposed to find by clear and convincing evidence that either the defendant committed the bad acts or the defendant didn't.
Correct.
Right?
Correct.
Right. And so you're telling me that there has to be a specific objection that was raised before or after that the trial judge didn't do what the trial judge was supposed to do in the first place in order for them to preserve it?
The trial judge did not have the benefit of McLean. I don't know that the trial judge had to do it at the time that this was presented to him. And I think therefore...
Okay, so your argument is that because the trial judge did not have the benefit of McLean, that this is an error or it's not an error, or if it's an error, then it's harmless error, despite the fact that you can't show that, that there's no reasonable probability that it didn't affect the verdict.
Well, the only way I could show that is, like, as I mentioned before, at trial, without this evidence, he was also convicted. Now, he got a new trial after that by the trial judge, so this was never reviewed by this court. But you have the facts of the testimony to show that it was clear and convincing. This is not one of those cases that it was nebulous, at least not in my opinion. And it was something that's really in doubt. These people came forward. They were older. They were registered nurses, I believe. They came forward.
So basically, I think your argument is that in all cases that are pre-McLean, that it doesn't matter whether the trial court made the finding or not, that, we just go to the record and see what was presented to the jury. I mean, in every case that comes along, we have to decide from here on out that we just kind of set McLean aside and then look at what the jury was presented with, even though it wasn't presented to the trial judge, and make our determination that way.
Well, I think that within that several-month time period, I think that's something.
Do you think the Florida Supreme Court would approve an opinion like that from our court if it was reviewed by them?
I think it could well, yes.
Think so?
I do, because if you review it, there are plenty of facts in the record to support the clear and convincing finding. The judge...
Would determination of credibility of witnesses be necessary to determine whether there's clear and convincing evidence that the Williams rule incident had occurred?
I would think so.
Are we in a position to do that for the record?
Because of the testimony, I think you are. I don't think you can see their demeanor, but I think you can tell from the evidence from the trial, from the record, the way it was described in closing, how these people testified, and that kind of thing. I think you can tell from this record. And
explain to me how, we get back to the harmless error analysis now. Explain to me your analysis or your argument that there's no reasonable probability. Explain that to me.
Okay. We have the first trial.
Because you're saying now that all this was presented to the jury, they heard all this testimony, and then we can look to the record. We can look to the record and say, we think it's clear and convincing evidence. Now, if that's the case, how can you argue that there's no reasonable probability that this didn't affect the verdict?
Well, just by virtue of the first trial. The first trial, he was convicted of the same offenses.
So you're saying that's a proper analysis for us to go back and review what was presented in a prior trial and say, okay, based on that, there was a conviction, and so you know, that's part of the analysis.
We don't have to review went back on, and we have a
I
prior
have not,
trial in this case.
I've never heard that argument.
No, well, we have a prior trial in this case. Most cases you wouldn't have a prior trial, but it shows that there was enough evidence at one time to convict him without the Williams Rule evidence. Now the fact we have Williams Rule evidence that was permitted to be introduced doesn't change the aspect of the case that we have a victim who came forward, who recalls this, and the proof was clear just with her testimony. Most of the closing was revolved around what the victim did.
Okay, before your time exhausted, I think I've got some concessions from you. Number one, you conceded that you didn't present a sufficient showing to the trial judge to allow the trial judge to rule that this defendant committed these prior bad acts by clear and convincing evidence. I mean, I think you've conceded that, haven't you?
I don't recall any place in the record that exists. That's correct.
Okay, thank you.
All right.
Just briefly, in a case where 80 to 90% of the case or the testimony revolved around the Williams Rule evidence, I don't see that any possible way that it could be viewed as harmless.
But what about where you raised it?
Well,
what about this
the
business?
best that I can point to in the defense written opposition of admission to the evidence at page it's in the record at page 48. Collateral crime evidence is not. This is in the written portion as opposed to in the testimony in the argument. The collateral crime evidence is not sufficiently similar to the charged offense to constitute similar fact evidence. The only arguable similarity is that the alleged child molestation occurred in a familial setting. Again, since Barber was the law of the district at the time,
Well, but you also had all the other districts who said to the contrary. I mean, if you want, I mean, what you just discussed here was sufficient similarity. Where did anybody ever say to the trial judge, you got to find that by clear and convincing evidence that this guy did this?
Well, again, I know that the words clear and convincing evidence were not uttered during that hearing that I can recall.
Or even that you've got to find by some standard of proof that the guy did it. You didn't even argue that, did you?
Well, my recollection of the hearing in the transcript is that there was something along those lines, that these haven't been proven, that he's not been convicted, there's been otherwise no showing that he actually did these things.
Okay.
And I would just defer to the court to the record, refer the court to the record for that determination. Briefly on issue 10. This case occurred, this trial took place 28 years after the charged crime. The victim testified during her testimony that she recalled this occurring when she was 5 years old, that the way she was able to figure out when this occurred was by discussing it with her mother. Her mother was...
Is this on the time frame? Well, first of
Right,
all, you didn't argue it initially. Secondly, you're out of time, so I'm going to cut you off here.
Okay.
Thank you, counsel.